Let's get started with Canada, the Illusion of Freedom and System of Control, Part 2, Canada, a Country Without a Constitution. A factual examination of the constitutional problem by Walter F. Kuhl, Member of Parliament, Jasper Edson, 1935 to 1949. This pamphlet was published in January of 1977. It is therefore easy to see why Canada is not a confederation. Dr. Maurice Oliver, Joint Law Clerk, House of Commons before Special Committee on British North America Act 1935. This specific committee minutes is very difficult to find because in it there are many Canadian legal scholars, constitutional experts that are saying very much the same thing. It is therefore easy to see why Canada is not a confederation, as well as they're saying the BNA Act was never a constitution, never intended to be a constitution, not legally a constitution, but a statute of the British Parliament. I have always contended, for reasons too long to enumerate here, that Canada, has not become either a confederation or a federal union. Dr. Oliver in a personal letter to Mr. Kuhl, May 30th, 1936. Oops. There is probably no political issue in Canada on which there is more lack of information and more misinformation than on the constitutional question. The stalemate and impasse which the governing authorities in Canada have reached on this question seem to indicate that there is and has been something very fundamentally awry in Canada's constitutional history. For almost half a century, this controversy has been raging without a satisfactory solution having been arrived at. Many Canadians, myself included, have had enough of this bickering between politicians and are determined to do something to bring this internecine strife to an end. The purpose of this booklet is to indicate in some measure what I, as a member of the House of Commons and as a private citizen, have attempted to do to bring order out of the constitutional chaos in which Canada finds herself. Democracy is successful only in proportion to the knowledge which people have with respect to their rights and privileges. That is so absolutely very true. It is my hope that the information contained in this brochure will assist Canadians to that end. Immediately following the recent Quebec election, I sent to Mr. René Lévesque a personal letter in which I indicated my conception of the constitutional rights which the provinces of Canada enjoy at the moment. At the conclusion of this booklet will be found a reproduction of this letter. Included with this letter was the additional material found in this booklet. A copy of my letter to Mr. Lévesque, along with copies of the additional material, was subsequently mailed to each of the premiers of the provinces of Canada. Each of the premiers of the provinces of Canada received this information. I desire to express my gratitude to Mr. R. Rogers Smith, who was my private tutor for almost the entire 14 years, during which I served as a member of the House of Commons, brought to my attention facts from the statutes at large, from the archives, and from original historical sources, the material upon which this brochure is based. Walter Kuhl and Russell Rogers Smith are two of my heroes, a source of inspiration for me, and also a big part of my research. Russell Rogers Smith and Walter Kuhl point me in the right direction to what acts and statutes to look at to figure out this crazy situation that Canada has been in since 1867. Well, it started in 1867. We've been under the rule of de facto government since December 11th, 1931. This document is very hard to read as it's handwritten, but later on in this booklet, it describes exactly what the handwritten portion says. On the left, we have the submission for the British North America Act from the Colonial Office of the UK. On the right, we have the submission from the delegates of Canada resulting from the Quebec resolutions. This is what the Canadian delegates wanted, and this is what the British North America, or the British monarchy and parliament wanted. On the left is the preliminary draft by the Colonial Office. This means the domination of the colony, the uniting of the colonies into one dominion. This is the basis of the British North America Act. On the right is the desire of the provinces to unite into a federal union, which means freedom. Drafted by John A. Macdonald before he received his title, one draft is diametrically opposed to the other. It's a copy from Inside Canada by Russell Rogers Smith, which I may be doing more videos on all his work as well. So on this side, we have the Canadians wanting their freedom. On this side, we have the UK and the Crown saying, no, 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 we can't lose another or a bunch of colonies. What we'll do, we'll unite the colonies. This is a letter from Dr. Bouchain, who was the clerk of the House of Commons in Canada. Dear Mr. Kuhl, I see you are still following a good policy. The idea is progressing. The only thing wrong with it is that it has been proposed by a cabinet minister. So Dr. Bouchain, 1940. So Dr. Bouchain says, this is awesome, this is amazing. The only problem, it's coming from an MP instead of a premier or the prime minister or the justice minister. This is a copy of a personal note sent to me by Dr. Bouchain following a speech I made on the Canadian constitutional problems on June 5th, 1940. Walter Kuhl. Canada House of Commons official report. Speech of W.F. Kuhl, Jasper Edison, on the subject of a distinctive national flag and constitutional problems in Canada. Delivered in the House of Commons on Thursday, November 8th, 1935. Now, you would think that constitutional problems in Canada would be up here, and secondly, a distinctive national flag down here. That just tells you what the government of Canada thought about all of our newfound freedoms from 1931, December 11th, after the Statute of Westminster was enacted. They continued the illusion that nothing changed. Nothing changed, but now we need a distinctive national flag. There's no constitutional problems. That's secondary to a distinctive national flag. That's crazy. Anyway, carrying on. So they were talking about the national flag issues, and Walter Kuhl, during his time, started talking about constitutional problems. But personally, I consider that under the constitutional conditions prevailing in this country at the moment, such action is premature. Of course it is. There are other and more important actions to be taken before it is appropriate to adopt a new flag. Yeah, like forming a country before we have a flag. Country, then comes the flag. The flag question is just one of the many anomalies which exist in Canada's constitutional position. I contend that the people of Canada are not being consulted in the manner in which I believe they ought to be concerning their rights in these questions. To account for anomalies, I wish to indicate, Mr. Speaker, my reasons for contending that the method that is proposed to attempt to remove these anomalies is improper and undemocratic. To do this, I first wish to endeavor to account for the constitutional circumstances in which we find ourselves at the moment. The question which must occur to every honorable member of this House and every other citizen in this country is, why do such anomalies exist in our constitutional position? How did they come about? There must be something in Canada's constitutional history that accounts for the circumstances in which we find ourselves. No other part of the British Empire finds itself in the same circumstances. Why are these conditions peculiar to the people of Canada? Very good question. The matters which I wish to discuss are those with which every public school child in the 7th and 8th grades, every high school student, and certainly every voter should be thoroughly familiar. Every citizen in the land should know by what authority we do things in this country. Every citizen in the land should know by what authority the government does things in Canada. On several occasions during the past two parliaments, I have argued the case I am about to introduce, but very little attention was paid to my statements either in the House or out of it. I consider that the situation which I shall discuss is of such importance that a reply and a comment should certainly be forthcoming from the acting Prime Minister, Mr. Isley, the Minister of Justice, Mr. St. Laurent, and for that matter, from all honorable members of this House. I and the people who have sent me here have a right to know whether there is or is not a basis in fact for my contentions. And if there is, they have a right to know what is going to be done about it. That's easy. Nothing was going to be done about it. The illusion has continued for almost 90 years since the enactment of the Statute of Westminster. Almost 90 years. The illusion of Canada continues. The illusion of freedom and in the system of control continues. I propose to make a reasoned argument supported by the best evidence I have been able to secure. If my argument is to be controverted, I demand that it be met with a reasoned argument and not with personal abuse and statements which are wholly irrelevant. So he goes on to state there was in 1938 he brought this material up as well, and there was some abuse from some of the other MPs. Mr. Thornton, would the honourable member indicate where he gets these queer ideas? Mr. McNichol, he has queer ideas of his own. So, rather than look into the information and acknowledge it, which they all knew, in 1938, they still knew. 1931 was only 7 years prior. So they knew the conditions of the country and the government at that time. They just chose to carry on as if nothing changed. Continue the illusion. Walter Kuhl says, I placed on the Hansard on February 10th a clear outline of the reasons for my statement. If the honourable member wishes to refute any of the facts or arguments which I placed before the House, I shall be pleased to hear the refutation. No one has ever refuted anything Walter Kuhl brought to the House of Commons. None of the information and none of his statements have ever been refuted by any person in the House of Commons. However, he was mocked and ignored. What does that tell you about the Canadian government? They didn't want to know about this information. They chose to ignore it on December 11th, 1931. And a lot of the people still in the government were in the government back then. Continuing on. In submitting my argument, Mr. Speaker, I wish to assure you that I am actuated by the highest possible motives. We proudly proclaim our faith in democracy. We proclaim it from the housetops. I wish to urge that we practice what we preach. Let us demonstrate democracy instead of merely paying it lip service to it. Exactly. The rule of law, the color of law. Big difference. It is my desire to see the people of Canada consulted where their fundamental rights are concerned. I wish to see government of the people, by the people. Don't we all? Don't we all? This is the only way we're going to solve our problem, is a government by the people, for the people. It's the only way we're going to solve our current political issues. I am speaking as a native of Canada. The matters on which I am to speak are of fundamental concern to every citizen of Canada, regardless of his or her political persuasion. Of course it is. Canada is not even a country. And you're bickering between NDP and liberal and conservative. They're all de facto. They all know it. It's all a show. It's all a show to maintain their power, control, and money. Continuing. They are among the most serious matters upon which a citizen can be called to think. They are the bedrock considerations of human government. Absolutely they are. Absolutely. It doesn't matter if you're right-leaning or left-leaning or libertarian. The Constitution is a Constitution. Laws are laws. We either follow the rule of law or we live under the illusion in the color of law. It's very simple. In order to endeavour to account for the contradictions in Canada's constitutional position and to suggest a remedy therefore, I wish to lay down some fundamental premises on which I shall base my entire argument. So Locke said, men being by nature all free, equal, and independent, no one can be put out of this state and subjected to the power of another without his consent. The only way whereby anyone divests himself of his natural liberty and puts on the bonds of civil society is by agreeing with other men to join and unite into a community. That says a lot. In the Declaration of Independence, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. Among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. The given consent, not the implied consent. There is a big difference between implied consent and given consent. If you don't object to something in their system of control, that is implied consent. Period. Their system works on presumptions, assumptions, and implied consent. Continuing on, a federal union defined. Definition of a federal union. Bouvier in his Law Dictionary defines federal government as a union or confederation of sovereign states created either by treaty or by the mutual adoption of a federal constitution. Dr. Olivier, Joint Law Clerk of the House of Commons, on his report of the Special Committee on British North America Act said, a confederation is a union of independent and sovereign states bound together by a pact or treaty for the observance of certain conditions dependent upon the unanimous consent of the contracting parties, who are free to withdraw from the union. This report from 1935 on the Special Committee report on British North America Act is very difficult to find because many of the people involved had statements like this. Canada never confederated. The BNA was not intended or in law any form of a constitution. It was a statute of the British Parliament, period. A.P. Newton, in his book entitled Federal and Unified Constitutions, says, a federal state is a perpetual union of several sovereign states, based first upon a treaty between those states or upon some historical status common to them all. Secondly, upon a federal constitution accepted by their citizens. The people of Canada had no vote on the Constitution Act 1867. In fact, people in Nova Scotia, 31,000 people, the voting majority, said, whoa, we don't want this to pass. Whoa, 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 whoa. So they voted to stop it. Not only that, the choice to stay under British rule or to take our freedom and create the Canada that people wanted, a Canada by the people, for the people, there was no vote on that after the passing of the Statute of Westminster. There was no vote on the Constitution Act 1982 or the Charter of Rights and Freedoms. These things are not constitutions. They were not accepted by the citizens of Canada because we were not given the opportunity, we were not given the information, education, and opportunity to vote on any of these issues. The Constitution of our country, the people of Canada were not given the opportunity to vote. Not only that, they were not properly informed of our newfound freedom that happened December 11th, 1931. 2 points stand out prominently in these definitions. The first is that the states which form the Union must be sovereign, free and independent before they federate. The second is that the federal constitution which forms the basis of the Union must be accepted by the citizens of the federating states. Number one, were the provinces sovereign, free, and independent before the Union? Before the Union? No, they weren't. They were British colonies. Secondly, did the citizens of these provinces that formed the Union, did they accept the Constitution that forms the Federation? No, they didn't, because we were a British colony. We were British subjects. Do you think the Queen cared what the people of Canada thought? No. She was supreme ruler of Canada. She didn't care what we thought as the people of Canada. So the BNA, again, it was a statute by the British Parliament that received royal assent from the British monarchy, Queen Victoria. And did she care what the people of Canada thought? No. Just like the rest of her colonies. No, she didn't. Australia federated. The people of Australia were provided with 2 opportunities of voting on their constitution, as it should be. Federal Union desired in 1867. The preamble to the Quebec Resolution reads, "The best interests and present and future prosperity of British North America will be promoted by a federal union under the Crown." Clause 70 of the Quebec Resolutions indicates that whatever agreement was arrived at by the delegates would be submitted to the provinces for their approval. Well, of course. The provinces have to approve anything. That they're not just going to jump into an agreement and say, okay, there you go, send our delegates, sign us away. No. They want to see whatever agreement was arrived at, and they want to have the opportunity to vote. Canada not federated under the BNA Act. The next question is, did Canada become a federal union under the British North America Act? I submit that the manner in which the bill was drafted and the manner in which it was enacted throw much light on the answer to this question. No. It was a United British colony. The act was drafted by the law officers of the Crown attached to the Colonial Office. So the provinces wanted to create a federal union, become free, and the British Crown is just going to say, okay, go be free. Just like that. When the British Empire was losing colonies like crazy. And all of a sudden, here's 4 colonies in Canada saying, we want to form a federal union in our own country. Of course they couldn't allow that. So there was what the Canadians wanted and what the Crown and the Brits wanted. Diametrically opposed. In reading accounts of the times, it's quite obvious that the bill which was drafted by the Colonial Office seems to have prevailed over that which was drafted by the delegates from Canada. Of course, it's a British bill. Of course it's going to prevail over the Canadian bill. The title and preamble of the bill drafted by the Colonial Office read, "The Union of the British North American Colonies and for the government of the United Colony. Whereas the Union of British North America Colonies for the purpose of government and legislation would like to be attended with great benefits to the colonies and be conducive to the interests of the United Kingdom." That is the preamble of the draft bill submitted to the Colonial Office, by the Colonial Office. Whereas the preamble of the bill drafted by the Canadians reads, "Whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire to form a federal union under the British Crown for the purpose of government and legislation based upon the principles of the British Constitution." I submit, Mr. Speaker, no evidence is to be found to show that the preamble which we find in the printed copies of the British North America Act in Canada was either discussed or approved in British Parliament. This preamble reads, "Whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire to be federally united into one dominion." This preamble was never discussed. This preamble was never discussed in British Parliament. It never passed British Parliament, and it did not receive royal assent. The preamble that did was this one. "Whereas the provinces of Canada, Nova Scotia, and New Brunswick have expressed their desire to form a federal union under the British Crown for the purpose of government and legislation based upon the principles of British Constitution." This is the preamble that passed through Parliament and received royal assent. This is the preamble that replaced that preamble when a copy came to Canada. And our government claims to base Confederation, the ratification of our Constitution, the creation of the nation of Canada based on that. And when that document arrived in Canada from Great Britain, after it passed through the British Parliament and then received royal assent, the preamble was changed. The preamble is one of the most important elements of a statute. It describes what the statute is and the purpose of the statute. It's then followed by the enacting clause. It's one of the essential elements of a legal statute. So this one passed British Parliament, received royal assent by Queen Victoria, and this one is what arrived in Canada and what we still have today. Fraud, ladies and gentlemen, fraud. I submit it should be evident from these quotations that the preamble, which was discussed, was that to be found in the Quebec resolutions, not the one we find in the printed copies of the British North America Act in Canada. So yeah, they discussed the Quebec resolution delegates proposal, and they said no. We're not going to let Canada leave and become its own country. Nope. We'll make it we'll unite it into one British colony instead. A pertinent question to ask at this point would be, when was the present preamble placed in the British North America Act? Why was it not discussed in the British Parliament? And furthermore, what is the significance of an act bearing a preamble which was not even discussed, let alone proven? Another point of significance is in connection with this, I believe, is the undue haste in which the bill was passed through the Imperial Parliament. When second reading was called for the bill, it was not even printed. So the second reading of the bill, there wasn't even printed copies for people to read and then understand and then vote on. So in the Hansard of February 27, 1867, Mr. Hatfield said he rose to ask the government by it was the second reading of this bill had been fixed for tomorrow. It was one which affected 4 million people of 4 million of people, and upon which great doubts and indifference of opinion were entertained. It was not yet printed, and was of so important a character that he thought some little time ought to elapse after it was in the hands of the members before it was introduced, in order that some little consultation should take place upon it. He was not at all sure that he should be opposed to it, but he certainly required more time to consider it. So, on the second reading, it wasn't even printed yet. None of the members voting on it had the opportunity to read it for themselves. It was just bam, there it is, vote. He, Mr. Hatfield, thought that a bill of such great importance ought not to be passed through Parliament with such haste. It was read a third time in the House of Lords, only on Tuesday night, and 2 days after they were called to give it a second reading in that House, the House of Commons. That was a bad precedent to establish and might produce ill effect at another time. If the bill had been delayed for only a few weeks, the people of Nova Scotia would have been able to express an opinion upon it. He had not had the time to consider either the bill itself or the papers on the subject which had been put into his hands. So Mr. Hatfield saying, whoa, this affects 4 million people. We need some more time to read and process this. I have heard there is at present in London a petition complaining of the hasty proceedings of Parliament and asking for delay, signed by 31,000 adult males of the province of Nova Scotia, and that petition is in reality signed by at least half of all the male inhabitants of that province. So far as I know, the petition does not protest absolutely against union, but against the manner in which it is being carried out by this scheme and bill and by the hasty measures of the Colonial Office. This scheme and bill and hasty measures to push it through. Mr. Hatfield was an honorable person. Nobody pretends that the people of Canada prefer a nominated council to an elective council. I regret very much that they have not adopted another system with regard to their council or senate, because I am satisfied, I have not a particle of doubt with regard to it, that we run a great danger of making this act work ill almost from the beginning. For my share, I want the population of these provinces to do that which they believe to be the best thing in their own interests. Remain with this country if they like, or become independent states if they like. So Mr. Hatfield, again, he was a very honorable man, and he was expressing his concerns, and yeah, he was ignored as well. So from the evidence that Walter Kuhl presented, he draws these conclusions. The provinces of Canada desired a federal union, obviously. The Quebec resolutions provided for a federal union. Yes, they did. They were the draft that was sent to London for debate on the BNA. The bill drafted by the Canadian delegates at the London conference also provided for a federal union. So after they started talking at the conference, they said, okay, we're going to draft this. It was still freedom and a federal union. The Colonial Office was not disposed to grant the provinces of Canada their request for a federal union. Of course, the colonial offices would never grant Canada the permission to leave the colony of Canada. No, you're not going to leave. Yeah, we'll unite you into one British colony, but you're not going to leave. The British North America Act, enacted by the Imperial Parliament, carried out neither the spirit nor the terms of the Quebec resolutions. Well, no, it didn't. Nothing made it in there. They scratched everything the Canadians want, put it in what the Imperial Parliament lawyers wanted in there to not allow Canada to leave and united as a British colony. Canada did not become a federal union under the British North America Act, but rather a united colony. The privilege of federating, therefore, was still a future privilege. Yes, through the UK Interpretation Act, 1889, I believe, it clearly states that all dominions, and specifically refers to Canada, are colonies, and Canada is a united British colony. So there you go. They can call it a dominion in a free country, but under British law, it's a united colony. It's a united British colony. That's it. Period. In law. You can call it whatever you want, but in law, Canada was a British colony. Canada did not become a federal union under the British North America Act, but rather a united colony. The privilege of federating, therefore, was still a future privilege, and it still is today. The Parliament of Canada did not become the Government of Canada, much less a federal government. It became merely the central legislature of a united British colony, a legislative body whose only power was that of aiding and advising the Governor General as an agent of the Imperial Parliament. The Governor General was appointed by the Queen to rule over Canada on behalf of the Crown, Queen Victoria. The British North America Act was enacted by the Imperial Parliament, was not a constitution but merely an act of the Imperial Parliament which united 4 colonies in Canada into one colony with the supreme authority still remaining in the hands of the British government. There you have it, ladies and gentlemen, right there. Further evidence. As further evidence that the British North America Act was not a constitution and that Canada did not become a federal union, I refer to the definition of the term dominion, which is to be found in Section 18, Paragraph 3 of the Interpretation Act, 1889. Excuse me. It reads as follows. The expression colony shall mean any of Her Majesty's dominions, exclusive of the British Islands and of British India, and where parts of such dominions are under both a central legislature and local legislatures, so central and provincial. All parts under the central legislature shall, for the purpose of this definition, be deemed to be one colony. Canada was one British colony. There was no confederation. There was a unification of 4 British colonies into one British colony. That's it. That's all the BNA did. Except in Canada, no other country in the Empire had a central legislature and local legislatures. Therefore, according to this definition, made 22 years after the enactment of the British North America Act, Canada is deemed to be one British colony. To show that I'm not alone in my conclusions, I quote some of the statements of recognized Canadian constitutional authorities before the Special Committee on the British North America Act in 1935. This Special Committee on the British North America Act 1935, they really don't want that to get out because so many Canadian legal scholars and constitutional experts said things like this. Dr. W.P.M. Kennedy, professor of law, University of Toronto, he says, I think we have to get away from the idea that the British North America Act is a contract or treaty. I do not want to go into that, but it is true neither in history nor in law. The British North America Act is a statute and has always been interpreted as a statute. It's not confederation, it's not a constitution, it's not the creation of a nation, it's a statute from the British Parliament. Mr. Cohen, you do not subscribe to the belief that it was a pact or a contract? Mr. Rogers, I am thoroughly convinced it is not, either in the historical or legal sense. And then there's another quote by Dr. Bouchain, clerk of the House of Commons. He says, "It is quite true that if we apply to the British North America Act the principles followed in the interpretation of statutes, it is not a compact between provinces. It is an act of Parliament, of British Parliament, which does not even embody all the resolutions passed in Canada and in London prior to its passage in the British Parliament, where certain clauses that had not been recommended by the Canadian provinces were added." He goes on to say, "The evidence which I have submitted establishes to my satisfaction that there has been at no time in Canada any agreement, pact, or treaty between the provinces creating a federal union and federal government, The privilege to federate, therefore, was still a future privilege for the provinces of Canada." So, once again, our federal government is de facto. After December 11th, 1931, everything changed. And they were no longer a government instituted by the British Parliament and British Crown. They were not elected by the people of Canada. There may have been votes, but it was a British system under the Governor General appointed by the Queen to rule Canada in her behalf. Since the condition of sovereignty and independence must be enjoyed by the provinces before they confederate, it was necessary that the British government relinquish its authority over them. This was done through the enactment of the Statute of Westminster on December 11, 1931. By Section 7, Paragraph 2 of this statute, the provinces of Canada were made sovereign, free, and independent, in order that they might consummate the federal union which they wished to create in 1867, but were not permitted to do so. Again, it wasn't a federal union. It was a union of 4 colonies into one British colony, still under British control. Since December 11th, 1931, the provinces of Canada have not acted on their newly acquired status. They have not signed any agreement, they have not adopted a constitution, and the people of Canada have not ratified a constitution. Still to this day, the people of Canada have not ratified a constitution. Such action should have been taken immediately upon the enactment of the Statute of Westminster. It is by reason of failure of the provinces and the people of Canada to take this action that all the anomalies in our present position exist. I agree that it's the fault of the provincial governments, also the federal government, but not so much the people, because the people weren't properly educated and informed on what happened. They weren't told how important the Statute of Westminster was. Otherwise, Canadians, I'm sure back then, would have voted to become free? Why stay under the thumb of British rule when we had the opportunity to create our own country? We have been trying since 1931 to govern ourselves federally under an instrument which was nothing more than an act of the Imperial Parliament for the purpose of governing a colonial possession. Not only has this anomalous condition obtained since 1931, but it has done so without any reference whatsoever having been made to the Canadian people. How can we, as people, trust our government when they hid this from us? They have not been consulted on anything pertaining to constitutional matters. Before there can be a federal union in Canada and a federal government, the provinces of Canada must be free and independent to consummate such a union. They have been free to do so since December 11th, 1931, but they have not done so. And I can hear people out there probably thinking or saying right now, yeah, well, we did in 1982 with the Canada Act. But the fact remains that the federal government at the time was de facto. They took their Canada Act to the British Parliament to have it passed, receive royal assent from a foreign monarch, Queen Elizabeth II, bring it back to Canada to patriate it, to patriate it. So if we had a constitution in 1867, as it says, the Constitution Act 1867, then how did Pierre Trudeau patriate the Constitution Act 1982 in 1982? Wouldn't it have been repatriate? But no, he patriated it. Were the people of Canada given the opportunity to vote on the Constitution Act 1867? No. Were they given the opportunity to vote on the Constitution Act 1982? No, they weren't. These are not constitutions, these are statutes. I therefore pose this question: whence does the Dominion Parliament derive its authority to govern this country? And every Canadian to this day should ask, where does the federal government, provincial government, derive its authority to govern this country? And they say through the BNA Act. And they say through the consent of the people. Both given and implied consent. That's what they'll tell you. The BNA Act became superfluous on December 11th, 1931. The Imperial Parliament cannot create a federal union in Canada or constitute a federal government for the people of Canada by virtue of the British North America Act or any other act. The Imperial Parliament cannot create a federal union in Canada or constitute a federal government for the people of Canada by virtue of the British North America Act or any other act, which is absolutely true in law. Only the Canadian people can do that. And it starts on the provincial level with every province and territory having constitutional conventions, writing our own constitution, and then forming our own government, the government by the people, for the people, the type of government we want to see, be it a democracy, republic, whatever. And then the people of all of the provinces can vote whether to form a federal union. Continuing, this can be done only by the people of Canada, and they have not yet done so. This was way back in 1945, and it's 2020, and we have still not done so. We are living under the illusion of Canada, the illusion of freedom in a system of control. I wish people could just understand that. Since December 11th, 1931, as an individual citizen of this country, I have had the right to be consulted on the matter of a constitution. I have had the right, along with my fellow citizens, to ratify or to refuse to ratify a constitution. But I have not been consulted in any way whatsoever. Same goes to this day, right now, because the government is de facto. They are dictatorships. They stole the power. Their power is an illusion. I assert, therefore, that until I, along with a majority of Canadians, ratify a constitution in Canada, there can be no constitution, and I challenge successful contradictions to that proposition. And the only thing they said in the House was, Mr. Pol Pot, were you born in 1867? Mr. Kuhl, not that I recall. Mr. Johnson, were you born? Were you? Mr. Pouliot, no. So again, they couldn't refute any of his evidence or facts. All they could do was mock him. That tells you a lot about the Canadian government. The House of Commons is for themselves. They have been perpetrating the illusion since 1931. Almost 90 years. Mr. Kuhl, those who were in charge of Canadian affairs in 1931 were under obligation to acquaint the people of Canada with the constitutional position obtaining at the time and prepare them so that they would be able to act upon their altered status. This says it all right here. Those who were in charge of the Canadian affairs in 1931 were under obligation to acquaint the people of Canada with the constitutional position obtaining at the time and to prepare them so that they would be able to act upon their altered status. Instead, they hid it. Prime Minister Bennett and all of the premiers hid it. That's treason. Mr. Kuhl. And now they start to go on about what about Section 7 about the Statute of Westminster? What about this? What about that? And Mr. Kuhl answers, I have already answered that. I have indicated the position of the British North America Act, and I have pointed out that it has not been accepted as a constitution by the people of Canada. And they keep going on, and he says, just exactly as I have said, there can be no constitution in Canada, whether it is on the basis of the British North America Act or any other act, until the people of Canada accept it. They have not accepted it. Period. It's the illusion of a constitution, in the illusion of Canada, in a system of control. The people of Canada have not acted on the altered constitutional status, hence the deplorable constitutional position in which we find ourselves in this country. I know of no country which is in such shocking constitutional circumstances as Canada. And it's even worse now after the whole Canada Act 1982 bullshit that Pierre Elliott Trudeau pulled off on the Canadian people. It's the same thing. De facto government taking a statute to British Parliament and the British Crown to have it passed. It's not a constitution. Legally, Canada is in a state of anarchy and has been so since December 11th, 1931. All power to govern in Canada since the enactment of the Statute of Westminster has resided with the provinces of Canada, and all power legally remains there until such a time as the provinces sign an agreement and ratify a constitution whereby they delegate such powers as they desire upon a central government of their own creation. Now, it resides with the provinces, yes, but it resides with the people in the provinces, because the provincial government at December 11th, 1931 became de facto the same as the federal government. The provincial governments were created by and for the Governor General to assist him, along with the central government, in ruling over Canada on behalf of Great Britain. Since December 11th, 1931, the Parliament of Canada has governed Canada on assumed power only. They lost all their power December 11th, 1931. They were all British subjects. We became completely free and autonomous December 11th, 1931. Their laws, and their government were done. It was up to Canadians to create our own government for each province and then federate if so desired. We were not given that opportunity. It was stolen from us. Obviously, the first act, that is, that the provinces of Canada shall sign an agreement authorizing the present Parliament to function as a provisional government. Of course, when this all happened, they should have done the right thing and said, okay, we're going to inform and educate, and everyone's going to vote, and we're free. But we're going to establish an interim government so Canada day-to-day operation can continue. Then when everything's established, we will start our new nation. That's all they had to do. Very simple, very simple. Secondly, steps must be taken then to organize and elect a constituent assembly whose purpose will be to draft a constitution which must later be agreed by the provinces and then ratified by the people of Canada. Of course. So every province, you have a constitutional convention, then there's a vote on the constitution, and it's either ratified or it isn't, and it's amended until it's ratified. Then through that constitution, the government is formed and elected, or formed, then it can be elected, and so on and so forth for each province and territory. And then once that is completed, all of the provinces can then vote to form a federal union, to become a real Canada. Proposals endorsed. To show that I am not alone in my proposal, I quote Dr. Bouchain from the evidence of the Special Committee on the British North America Act 1935. Again, there's more information from that Special Committee on the British North America Act in 1935 that the Canadian government is hiding, doesn't want people to see. On page 126 of the evidence, he is credited with saying, "The Statute of Westminster has altered our status. The time has come, in my humble opinion, when the British North America Act, except as to minority rights, should be transformed and a new constitution more in conformity with present present conditions should be adopted. Amendments here and there would be mere patchwork, which could not last. The people of 1935 are different from those of 1867. We the people want a new constitution. A new constitution must leave nobody with a grievance. A spirit of conciliation should predominate. For these reasons, the task must be entrusted to an independent body in which all the elements of the country will be represented. I therefore beg to suggest an imposing constituent assembly formed of eminent men coming from all parts of Canada. Provincial conferences attended by a few ministers meeting behind closed doors would hardly satisfy public opinion. The debate should be public. So he's saying let's have public debates and get it done. In 1935. But again, that special committee information is down the memory hole, I guess. I haven't been able to find it. If you can find it, let me know. Dr. Bouchain is reported as follows. I would suggest that the Assembly do not sit in Ottawa in order that it may not have the appearance of being dominated or even influenced by the Dominion power. Exactly. Get it out of Ottawa. Ottawa rents their land in the province of Ontario anyway. The Parliament, the federal government has no eminent domain because it's de facto. And as the western provinces are of such paramount importance in this country, I suggest the best city would be Winnipeg. Even back then, Dr. Bouchain, the clerk of the House of Commons, said that the western provinces are of such paramount importance to this country. It's kind of funny. And then it's not kind of funny. I think the time is ripe for a change in the Constitution. I do not think you would need much publicity in order to draw the attention of the people of this country that the British North America Act is inadequate. Whether our country should be changed from a dominion to a kingdom is also a subject which might be discussed. I would suggest that the country should be called the Federal States of Canada. This resolution is to be found at page 59 in the publication Prepare Now, issued by the Bureau of Information, Legislative Building, Edmonton. It reads as follows. So some people back in 1931 knew what the Statute of Westminster did. Whereas the Statute of Westminster, in granting complete sovereignty and equality with Great Britain to Canada and other nations of the British Commonwealth, has changed the relative positions of the provincial and federal governments as provided in the BNA Act. And whereas it is desirable and expedient in the interests of national unity that an interprovincial conference of appropriate representatives of the Canadian provinces be held for the purpose of reviewing and adjusting the constitutional relationship between the provinces and their central government with a view to providing effective democratic government in Canada. Therefore, be it resolved that without in any way prejudicing or jeopardizing the rights and privileges of any minority group in Canada, a comprehensive conference of representatives of the provinces be held for the purposes of considering the existing legislative and administrative organization in the provincial and federal spheres, a more expedient allocation of powers between the provincial and federal authorities, ways and means of facilitating the drafting, the adoption, and implementation of a Canadian Constitution in keeping with the rights granted in the Statute of Westminster. So there were people talking about it, just not the Canadian government, because they didn't want to lose their power, control, and money. I believe that the statements which I have placed upon the record are historical facts. I believe that the conclusions which I have drawn from these facts are the only ones which can be drawn from them, and I believe, consequently, that the solution which I have suggested is the only one adequate for the circumstances. If honorable members of this assembly can successfully dispute either the facts which I have submitted or the conclusions which I have drawn therefrom, I shall be prepared to withdraw those conclusions. Jumping down to Walter Kuhl's explanation of the Statute of Westminster, the Parliament of a Dominion in Section 2 does not refer to the legislative body sitting in Ottawa on December 10th, 1931. The legislative body sitting in Ottawa the day before the Statute of Westminster was passed, according to the Interpretation Acts of 1889, Section 18, Paragraph 3, was the central legislature of a united colony, whose only function and authority was to aid and advise the Governor-General as the agent of the British government. Section 2 does not validate the central legislature of a united colony as a federal parliament of a federal union. A federal union in Canada can be created only by completely independent and autonomous provinces, which Section 7(2) provides for. As a consequence of Section 11, the term Dominion can now be applied to a federal union, and the term the Parliament of a federal Dominion can now be applied to a federal parliament and not be inconsistent insofar as a definition is concerned. However, the British government can no more convert the central legislature of a united colony into a federal parliament of a federal union by changing the definitions than it can turn water into wine. So once again, the central government of a united colony is not a federal parliament of a federal union. And you can't make it so by changing definitions and smoke and mirrors, continuing the illusion. The only validity which the BNA Act has since December 11th, 1931 is as a guide to the creation of a federal union, which only the provinces can bring about. The provinces of Canada are free to use it as a guide in the creation of a federal constitution, or they may reject it completely in favor of a constitution of their own making. As an analogy, it might be said that the relationship which the original provinces entered into under the BNA Act was sort of a shotgun marriage. They were forced into a united colony against their will. The Statute of Westminster gave the provinces their independence so they could consummate a voluntary marriage, but they have not yet done so. Ever since December 11th, 1931, the provinces have been living common law with Ottawa and have had the right to terminate this arrangement at any time they wish, despite the Canada Act and all of the revisions of the BNA since then. This is the letter Walter Kuhl sent to René Lévesque after he won the election for premier in Quebec. Dear Mr. Lévesque, congratulations on your magnificent personal victory and that of your party Quebecois in the recent Quebec election. As a student of Canadian constitutional history and of Canadian constitutional problems for some 40 years, I am tremendously interested in the constitutional implications of your recent political victory. For 14 years, from 1935 to 1949, it was my privilege to serve as a member of the House of Commons from the province of Alberta. The withholding of assent to some Alberta legislation in those years by the Lieutenant Governor and the disallowance of other Alberta legislation by the people at Ottawa set me to investigating how these things could be. I was assisted in my studies by R. Roger Smith, who is personally acquainted with the one-time private secretary to John A. Macdonald at the time when the BNA Act was being enacted. Although this source, I have become acquainted with much more information concerning the history of the BNA Act which is not to be found in textbooks. All this information has led me to the conclusion that the existing constitutional circumstances are shocking to the point of unbelief. However, in my considered opinion, after 40 years of intensive study, these existing constitutional circumstances are of such a nature that they can be of extreme advantage to you in your governing your province. I am enclosing some of the addresses which I delivered in the House of Commons on the subject, as well as copies of a pamphlet by Mr. Smith dealing with the same subject. If you have not already been made acquainted with this material, I trust it will prove enlightening and helpful to you in the constitutional considerations you obviously are going to be involved in. Although the enclosed material should give you a clear outline of what I conceive your present standing constitutionally, as a province, I would like to give you a brief summary of what I believe to be your present position. This is not only Walter Kuhl's opinion, this is the opinion of many Canadian legal scholars and experts. So far as separation is concerned, rather than it being necessary to seek separation rights through a referendum, the province of Quebec is already completely constitutionally separated from the rest of Canada. This is equally true of every other province in Canada and has been so since December 11th, 1931, through the Statute of Westminster. How can you be divorced if you have never been married? In other words, ever since the enactment of the Statute of Westminster in 1931 by the British government, each of the provinces of Canada have been a completely sovereign and independent state, and because the provinces have signed nothing since then constituting a federal union and a federal government, and because no such has been ratified by the people of Canada, the provinces still enjoy the status of sovereignty and are privileged to use it in any way they seem fit. As you will observe from the enclosed addresses, I quote eminent Canadian constitutional authorities as suggesting that the only and logical solution to this existing constitutional circumstances is the drafting and the adoption of a proper federal constitution in which the provinces can reserve for themselves any and all powers necessary to enable them to govern their provinces successfully. He goes on to review what he reviewed in the House of Commons, but once again, The British North America Act, as enacted by the Imperial Parliament, was not a constitution but merely an act of Imperial Parliament which united 4 colonies in Canada into one colony, with the supreme authority still remaining in the hands of the British government. The privilege of federating became realizable for the provinces of Canada only through the enactment of the Statute of Westminster on December 11, 1931. Through this statute, the Imperial Parliament relinquished to the people of Canada their sovereign rights, and through them to the provincial governments as their most direct agents. Since December 11, 1931, the provinces of Canada have not acted on their newly acquired status in the forming of a federal union, nor have the people of Canada ratified a constitution. He goes on to say, therefore, the original proposition, namely, that all power to govern in Canada resides at the moment with the provinces of Canada, and all power legally remains there until such a time as the provinces sign an agreement and ratify a constitution whereby they may delegate such powers as they wish to a central government of their own creation. In meantime, Canada exists as 10 political units without a superior. So, through the fraud and deception of the Canada Act 1982, it's not legal or binding. It's not a legal or binding contract. And there we have it. I hope you enjoyed this presentation, and I hope you may have learned something. If you did, please share this information, and please do your own research. It's getting more and more difficult to find documents by Russell Rogers Smith or Walter Kuhl because the Canadian government doesn't want this information in the hands of the public. Simple as that. So I'll try and find a link. I've had this copy for a number of years now, but I'll try and find a link to post a link to this document, and stay tuned. We'll continue on. The next video is likely just going to be reviewing statutes from the UK and from Canada, proving that Canada is a country without a constitution through their own words and documents. That being said, thanks for watching, and we'll see you soon.